Hi, I'm Navras Adhikari, studying at Central Queensland University. My student ID is 1202760. I'm here to do a review presentation on the case of Thornton versus Sulen Parking Limited. I'm discussing this case on the basis of IRAC method. Let's start with the fact of the case. Thornton parked his car in the Sulen parking lot while he was at a musical performance. He received a ticket from an automatic machine. The ticket was printed at the time of issue and a statement that the ticket is issued subject to the condition posted in the parking lot. These conditions were posted in the office where you had to pay upon departures and on the wall opposite to the ticket machines. However, the posters were not so clear. The conditions included exempting Sulen from any liabilities for injury caused to the customers while their car was in parking building. Thornton was seriously injured when placing a goods in his trunk before leaving by another car. Now, I'm going to deal this case with in the IRAC methods. Let's start with the issue of the case. The main issue of this case are: number one, is the exempting condition that was posted in the garage is part of contract? Number two, does the ticket creates any legal relationship between the two parties, that is Thornton and Sulen Parking Limited? And third one, does the fact that the ticket was dispensed automatically matters? Now, let's talk about the rule. This case falls under the rule of offer and acceptance. When one party offers a contract and another party accepts, there exists a legal relationship between the offerer and offeree. If any party voids the terms of the contract, he or she will be liable to compensate all the losses or damages incurred. Okay, now let's talk about the applications. In the case, the issue of the ticket was regarded as an offer by a company and the plaintiff took it and returned without objections. His act was regarded as an acceptance of offer, since there is no chance to look at the conditions, reject them or get your money back. Effectively, the offer is made by Sulen in having the machine posted with the prices, and this offer is accepted when the driver places money in the machine. And now let's go to the conclusion. The conclusion of this case is the defendant cannot avoid the liabilities by relying on exempting conditions, because in order to show the plaintiff was bound by the conditions, it was necessary to show either that he knew of it or that the defendant had done when was reasonably necessary to draw it to his attention. Finally, the Court of Appeal declares that the exclusion clause did not form part of contract and therefore did not protect the defendant, that is Sulen Parking. By saying this, I am concluding my presentations. Thank you.